Good afternoon, everyone. There's always a slightly odd silence at the beginning of a webinar because you're just waiting for it to pick up. So if that's what you saw, first of all, apologies, but it's a pleasure to see you all this afternoon. My name's Chris Kessling. I'm Vice Dean of the Inns of Court College of Advocacy, ICCA or ICCA as most people call it, because it doesn't trip off the tongue that easily. I am delighted to introduce to you, first of all, my colleague Patrick Ryan, who is Director of Online Learning and very much responsible for much of the structure and content of part one of the ICCA Bar Course, which you'll hear all about in due course. I'm also extremely pleased to introduce Kane Deach, who is a current current student on the ICCA Bar Course. And he's currently on part two. Of course, he's been through part one and he's here really to provide, we hope, answers to any questions you have in the most authentic way. Because if I tell you how great everything is, and Patrick does, you might not quite believe us. If Kane does, then I'm sure it's got that, that level of authenticity about it, which is going to make a difference. What we want to do today for all of you is really to take you through what our bar course is all about. We want to demonstrate to you how it works, both on part one and part two. We want to tell you how the various course cycles work, because I know that can cause a significant amount of confusion. We can tell you about the fees, funding opportunities, the application cycle, because applications for the bar course are now open, and also really what it leads to and the sort of results that we, or our students more precisely, attain during the course. So that's my phone going off in the background, but that's, oh, it's been picked up, which is great. During this, of course, there will be a number of questions you have. There's two buttons at the bottom of your screen. One is Q&A and one is chat. Can we ask you, please, to use the Q&A function rather than the chat function, because it just makes it easier for us to focus. And what we'll be doing is answering as many questions as you have, and we will be stopping on occasions to enable us to do that. And we're all going to take part in answering these. I know it's a bit strange being online because we can't see you, you can see us. Strangely enough, there's been, or this is a real positive, there's been more recently, of course, so many in-person visits. We're at the Bar Council Pupillage Fair, and we have a number of events coming up as well, which I'm going to tell you a little bit more about as we go through this. But there I go talking. Let me just give you an overview before I hand over to Patrick. Our bar course is unusual and it's innovative in that it doesn't work like other bar courses from other providers. Our bar course is set out in two distinct parts. Part one is an online only course of self-study, which means you can do it at your own pace from any location, and you can do it following a guided pathway, or you can do it more flexibly over a longer period. Once you finish, and during part one, you do what are known as your BSB, your Bar Standards Board centrally set assessments in civil litigation and criminal litigation. Patrick can tell you a bit more about those. You take your examinations, your assessments, either online or in person, and then once you've completed that, you move on to part two, and on part two, that's an in-person course. That's where you come and join us for up to 19 weeks. It's an under 6 month course, part two, and you come and you get taught in the Inns of Court. I think you're currently being taught at the Inner Temple, Kane, isn't that right?
That's right, yes, in the newly refurbished suites in the Temple.
Absolutely. So Kane can tell you a bit more about that in due course. But that's your overview. What I'm going to start now with is part one of the course, what it's all about and what you'll be learning. So I'm going to hand over to Patrick at this stage.
Thanks, Chris. Good afternoon, everybody. It's lovely to be with you, and thanks for joining us for the webinar. In terms of part one, Chris has already given you a sort of very brief introduction to the part one of the course. It's worth just taking a moment to explain why we structure the bar course in that way, particularly as far as part one is concerned. it has two real benefits to you as students on the ICCA Bar Course. The first is in terms of cost, because we only ask you to pay for part 1 when you're doing part 1, and we only ask you to pay for part 2 when you're doing part 2. And the reason for that is that when the ICCA Bar Course was set up, one of the things that we were very keen to do was to try and address the problem of students who were taking the bar course, sadly weren't passing the bar course, but had spent a lot of money paying for a bar course, which they then weren't able to use. So the system that the ICCA puts in place is to say, okay, well, let's get you over the hurdle of the part 1 exams, civil litigation and criminal litigation. They're knowledge-based exams, they're set by the BSB, and they are the greatest hurdle that students encounter in terms of successfully completing the bar course. In other words, if you don't get through those exams, your chances of getting through the course are really very small indeed. So we draw them out of the, we draw them away from the skills subjects that Chris was talking about on part 2, and we try to coach you specifically to get through those exams using the online course, the online courses, I should say, in criminal litigation and civil litigation. As Chris says, they're entirely flexible and they're accessible whenever you want to do it. So once you're enrolled on the part 1 course, you can work during the day, you can work in the evenings, you can work at weekends. The material's always there for you. You can decide which order to do the material in. So if you've only got 2 hours to study a shorter lesson, you can find a shorter lesson to do in that time. If you've got a longer study period, you can take on one of the longer lessons or one of the longer subjects that split over a couple of lessons. What's unique about the part 1 course in terms of the material that you encounter is the way in which the ICCA uses case studies to try to put you in the position of barristers who are, and judges indeed, who are tackling the kinds of litigation problems and evidential problems that you will face in real life, and that prepare you for those assessments. So we have 7 case studies that run throughout the civil and criminal courses. And at various times in the course, we will take you into a conference with a barrister. We'll take you into a courtroom, into a hearing, to see how that case is progressing, and so that you can see how the things you're reading about in the textbooks and learning about in the online course actually play out in real life. So we are very keen to show you the practical implications of the litigation rules you're learning and the evidential law that you're learning. The way we've done that is within the case studies themselves. When we were designing the course, was to send all the cases to practicing barristers and judges. And we asked them to conduct the conferences and hearings as they would do, as if this was a real case. We recorded what they did, and those then became the scripts for a series of films that pervade through the part 1 course, which were then filmed in 2019, 2020, at Blackfriars Crown Court, and then at the Rolls Building for the civil films, using a professional production team and professional actors playing the parts of the clients and the barristers and the judges and everybody else involved in the process. So we really try to show you how these things that you're learning about play out in real life and will play out when you get into practice. As I said, all of the materials, including the films, were designed by practitioners and legal academics. There are, throughout the course, there are podcasts with people who do the kind of work we're trying to teach you about day in, day out. So in the lesson on arbitration, for example, we have a really great podcast with a partner in a law firm whose sole practice is essentially to do arbitration after arbitration. In the appeals section in crime, we introduce you to the Common Sergeant of London, His Honour Judge Marks, King's Counsel, I should say now, who talks to you about the work of the Court of Appeal. He sits in the Court of Appeal Criminal Division, and he talks to you about how the work in the Court of Appeal is done. So you are hearing from people who are doing the work that you want to do day in and day out. One of the most important parts of the part 1 course is the opportunity for self-assessment. At the end of every lesson, at the end of every unit, at the end of every 2 or 3 units of lessons, we ask you to take a self-assessment test. Those are questions that have been designed to look and feel exactly like the questions you'll be faced with in the part 1 exam. So you have ample opportunity not only to get your head around the subject matter, but also to practice the type of questions you will be asked in the exam. The effect of all of that has been extraordinary in terms of the way in which the ICCA students who've gone before you have performed in these assessments. We've had situations where regularly 100% of the candidates, the ICCA candidates have who've done the exams have passed at a particular window. I think our current average pass rate across both subjects is about 93, 94% of ICCA students passing when they do an exam. So you can be hugely reassured that if you're offered a place on the ICCA course and you go through the Part 1 course, your chances of passing these exams are off the charts fantastic. And that is down to, firstly, to Chris and his team and the work they do in selection, identifying the right people to come on the ICCA course. It's down to the hard work of people like Kane that they put in when they're doing the course. And it's also to pay credit to our team, the team that Jane and I run, down to the expertise of the academics and the e-learning professionals who've designed the course in the way in which that's been taken on. It is a self-study course. It's not for everybody, and I want to make that really clear from the outset. If you're somebody who really thinks they would benefit from face-to-face teaching, then the ICCA Part 1 course isn't for you. But let me reassure you, those who have come on the course, and everybody has doubts about it, because it's certainly before the pandemic, it was rare to have a non-face-to-face, non-tutor-led course to teach these subjects. And when we started, we were anxious about whether it would work. But what we can reassure you of is that it does work, that if you really think and reflect upon your own learning style and your own learning and what you've learned so far, we think that this course is really beneficial for an awful lot of people. And so you might be worried about it, but don't let the worry put you off from applying and reflecting on whether or not this might be the course for you. The pass rates would suggest that a lot of people benefit from this way of studying. Kane, I'm going to hand over to you, if I may, for just a couple of minutes, just to give your reflections on Part 1 and either add or disagree with anything I've said.
No, I actually just wanted to pick you up on the point about the self-assessment questions.
Yeah.
I found, for me personally, they were an excellent way to prepare for the exams because, like you said, they mimic the actual format of the questions in the exams themselves. So I actually found in many a situation when in the exams themselves, I found that some of the questions that were being asked were, very similar in kind of style and content to the mock questions that had been prepared. So in that sense, I found the self-assessment questions at the end of each unit incredibly helpful. And I would also say as well, with the self-study element as well, I completely agree with what you're saying, is that it does put a lot of emphasis on each student to really do the work and really focus, which I think a lot of people, including myself, really engage with. But it is just something to bear in mind.
That's really helpful. Could I just butt in with a couple of bits? And I'm going to answer a question that's come up as well. It's worth mentioning, and we were absolutely delighted, as Patrick said. A number of the cohorts that have been through our course, the success rates have been truly exceptional, and we're delighted that actually our first one, for example, when we found out that 100% of the students have passed, we fell off our chairs almost. I mean, it's unheard of. The reality is that the results are published independently by the Bar Standards Board, so they are BSB published statistics, and we can provide those to you. But if one looks, for example, at the December 2021 report, that our pass rate within that is 93.98%. And to put that into perspective, that's against an average across all other bar training providers of some 48.06%. So I think that gives some perspective on the success. In terms of the question that we're asked here, could you work whilst doing Part 1 and how long does it take? I'm going to deal with course cycles, but it's relevant to deal with it here. So you can start Part 1 in either September each year, so the next intake would be September 2023, or in January. So the next one for cycle 2 of Part 1 would be January 2024. If you follow the guided pathway, it's going to take you 12 to 14 weeks to do, which means that you could start let's say you on cycle 1, you started your Part 1 online course in September 2023. You then took your exams in December 2023. You could then start your Part 2 course in March 2024, which would finish in July. So that's the way that would work. But, however, if you chose to take it over a longer period, because, for example, you were working full-time or part-time, the BSB exams take place in December, in April, and in August each year. So what you could do is you could start, sticking with a September start, decide not to take your exams in December, but instead take them in April, which means you could still start Part 2 in September. Alternatively, if you didn't take them in April, because you had a full-time job, you could take them in August. If you took them in August, you wouldn't be able to start Part 2 in September, but you could start Part 2 the following March. So that's the way it would work. So the reality is there's an awful lot of flexibility in Part 1, depending on what your particular personal circumstances are. I hope that answers the question. How many percent of the students pass your course and getting called to the bar? Well, we've given you the results for Part 1. In terms of getting called to the bar, the overwhelming, I haven't got a statistic, is exactly how many people have failed. I can tell you that our failure rate is in the single figures. So it's extraordinarily unusual. If you pass the bar course with us, and as long as you've done your 10 qualifying sessions and passed your fit and proper person test, then you can get called to the bar. That's very, very straightforward. In terms of our pupillage rates, I can tell you that 80% of our 2021 graduates have pupillage, which again is an extraordinary success rate for us. And much of that is the focus that we put on really preparing our students for pupillage. Shall I deal with this question now, Patrick, as well? How many places for Part 1 do you envisage being available?
that might nicely round off the section on Part 1, mightn't it?
Of course. We started because we only started this course in it seems long ago, but it wasn't long ago. September 2020. We started the course, and during that time, or at that time, we kept it very small. But actually, we are opening the course up, and so we anticipate taking up to 120 students on each cycle of Part 2, which means that actually we would take in excess of 120 students on each cycle for Part 1, because we recognise that not all of the students who start Part 1 are going to be going on to the next Part 2, so we will take more. We do not consider that there is going to be too much of an issue with people getting through. If you get through the selection process, then we anticipate there will be a place for you. I don't think I can say it any fairer than that. Okay, I'm going to move on to, we will try and answer your questions. I'm going to move on a little bit more to, excuse me, to Part 2 now. Part 2 is an in-person course. It lasts for 17 or 19 weeks, depending on where you start, around 17 weeks if you start it in March, or 19 weeks if you start it in September, because it takes into account the 2-week Christmas break. So that's the reason why. It means that if you are coming to London for the first time and you have to get a flat, for example, in commutable distance from London, you can get a tenancy for 6 months as opposed to 12 months. I will be dealing with scholarships as well. There are some scholarships in the inns, for example, that are residential, that provide you with a place to live during the duration of the course, which of course is extraordinarily helpful if you're successful in getting one of those. But where you're taught on Part 2 is within the Inns of Court. For those of you that have seen the inns, you'll have noticed that Lincoln's Inn, they went underground. They built this absolutely amazing space under the Great Hall, which is an extraordinary teaching facility. Inner Temple went overground. I sound like a womble now. They went overground. They went over the the library. And that's where Kane is being taught at the moment. I'll call on him in a moment to describe what that's like, but that's an amazing space. Gray's Inn have refurbished in a quite extraordinary way much of their teaching facilities. And again, our students have used those. And Middle Temple will be coming on board in due course and refurbishing a number of their rooms, which the Inns of Court College of Advocacy are going to use for teaching. So you are being taught in the heart of legal London. You've got the Royal Courts of Justice a stone's throw away. You've got the Old Bailey in the other direction, the stone's throw away. So you are surrounded by barristers, because of course that's where the majority of barristers in London work. And it is really important to us to really allow our students to feel and have a connection with the practicing bar, because again, there's a buzz about that we feel is very successful. Because what we actually want is from the practicing bar, we want there to be a recognition, if you like, a kite mark of quality for Inns of Court College of Advocacy students when they go to pupillage. And we think that's part of the reason that our students are successful in achieving pupillage, coupled, of course, with their extraordinary results and their hard work. Kane, I'm delighted to say, has told me that he's got pupillage starting in I think a family law set. But I'm just going to call on you, Kane, for a moment, just to describe really the teaching facilities that you have at the Inner Temple at the moment, if you wouldn't mind.
Yeah, sure. And like I said earlier, we're really lucky on my cohort because we're taught in the Inner Temple, and the facilities there have been very recently refurbished. So we're situated currently on the top floor, the 4th floor of the Inner Temple building. And all of the teaching rooms that we do, all of our advocacy sessions and, opinion writing conference, all of those things, they're all completely brand new, and all of the, the furniture and the facilities and all the IT in there is, like I said earlier, brand spanking new. And a real benefit of our sessions as well is that because of the facilities in the rooms, we're able to record our advocacy sessions. So we're filmed doing our advocacy work, and then we're able to reflect on that by looking at the recordings and seeing, points for improvement and that sort of thing. Another aspect as well, which me and some of my colleagues on the course have found quite strange, but also great, is that because we're in the Inner Temple building, and I think the library itself is on the floor beneath. Yeah. Because it is the Inner Temple after all, when you're in there studying for your course content and your upcoming sessions, you're often in the same room with a lot of very experienced and senior KCs and stuff like that. So like you said, because we're in the heart of legal London, your studies are constantly intermixed and, with the nature of the profession itself in the Temple. And another thing as well as, it's not just Inner Temple that have been refurbished, as well as there's also the garden room in Middle Temple, which has very recently been refurbished, and that provides an excellent place for everyone on the course to meet up and have lunch and that sort of thing. So my experience has been excellent so far because of all the refurbishments.
That's really helpful, Kane, and I think it's right to say that students get a discount on using Inns facilities, food, not alcohol, I think, but other drinks.
Yeah, no, definitely. And I found that because, everyone had a conception when you go into study in London, you kind of had this image of, everything's going to be very expensive. But my experience actually in the garden room, particularly at Middle Temple, is that it's very reasonably priced with the student discount. So it's always good to know if there's somewhere that's not going to cost you an arm and a leg to eat.
Absolutely. I recommend to all of you, you don't have to join an inn when you start part 1. You have to have joined an inn before you start part 2. But I recommend you do that as early as possible. Join the inn as a student member, because it's a one-off payment for life. They don't call on you after that of around £100. But it's really good in the sense of community, to get to know other students doing the bar course. You find out an awful lot about pupillage, what's going on about mini pupillage, a lot about advocacy competitions. We tell you that on the course anyway, but it really helps you sort of really intermingle with other people who are like-minded fundamentally. And also, if you haven't seen the Inns of Court, they're like oases in the middle of London. They are absolutely beautiful places. They all do individually their own open days, and I would recommend to all of you to come down to London and have a look around them. Gray's Inn, Inner Temple, Middle Temple, Lincoln's Inn, beautiful places to walk through. You can't get into them at the weekends, but you can get into them and walk around them during the week. So I recommend doing that. Let me tell you a little bit more about teaching on part 2. I will stop shortly and answer some of these questions, but we take an approach to teaching where we believe individual attention is really important. Our tutors are all barristers, they're all experienced barristers, and they all have significant experience in practice as barristers. So that is the quality of what you have working behind you, and we're extremely proud of our tutor team and the effort that they put in. Similarly, the course design and the materials, you get multiple briefs, again, produced by practicing barristers, and Patrick's already told you about the work that went into part 1. But in terms of groups, if you're doing advocacy, you're taught in groups of no more than 4 people. I do apologise. If you're doing conference, you're taught in groups of no more than 6 people in double-length sessions. When you're doing opinion writing, drafting, you're taught in groups of no more than 12 people. So it means that we move away from any concept of you feeling you're just one of multiple people in a room. This is very, very focused on helping you get through what you need to get through as far as the BSB exams. But more than that, we actually really want to help you as far as pupillage is concerned. We want to prepare you for pupillage. And we want to move away from that concept. I'm sure you've all been there where you do an exam and you think, oh, thank goodness for that. It's finished. I don't need to bother with that again. I never need to remember it. Actually, what we want is for when you're in pupillage and you're standing up in court, or when you're in practice and you're standing up in court, that actually the things that we've taught you on this course make a real difference. And that is an approach that we have adopted because we wanted to get away really from where bar training was some years ago before we came into the market. And bar training really wasn't respected by the bar. It was extraordinarily expensive. Many students didn't pass bar training. If they did, many students didn't get pupillage, and we wanted to change all of that. And that's why we've taken the approach that we have, really to bring bar training into the 21st century and make it work for the students, and so that they can get the outcomes they deserve. I'm delighted that we've been able to do that. On part 2, you will be doing advocacy. That's a big focus. It's in our name, of course, but you will be doing submissions advocacy, which for many of you have done mooting. It's quite similar to that. It's submissions to a single judge. You will be doing witness handling, which is split into 2 parts. Examination in chief, which is when you're eliciting the evidence from a witness. There's a number of rules and regs about that, if you like, that you can't lead the witness, you've got to tell them what to say. And then there's cross-examination, where fundamentally you're seeking to put your own client's case to the witness who's just give evidence, and also seeking to undermine that witness, perhaps to create doubt in the minds of a jury in a civil case, or indeed to win your case point blank in a civil case. But we call them criminal and civil advocacy, but there's actually a lot of crossover between them. We teach you conference skills, where you'll be sitting down with clients, you'll be taking instructions from clients, you'll be advising clients on the law. All of these are backed by realistic briefs in civil and criminal work. So you get a good idea of what's coming when you get to pupillage and indeed into practice. You will be doing opinion writing. It's a big thing that barristers do, apart from being in court, where a solicitor or indeed a direct access client will come to you and say, well, how does this work? What do I do here? Can you help me with the law? Or essentially, you're taking the law and you're applying it to the factual scenario that you're given and advising your client, but getting further instructions. That's what you do in conference. In opinion writing, you're giving that opinion. And then in drafting, of course, you are putting together statements of claim, you're putting together defenses and counterclaims. all of those things, particularly if you go into the civil area of practice, you will be doing. We also look at some criminal drafting, such as, for example, criminal grounds of appeal. So we cover all the bases. This is what really the bar course is intended to do. It's intended to act as a bridge, if you like, between the academic stage where you've done your degree or your graduate diploma in law and the pupillage stage, where you actually go in almost like an apprentice and you're shadowing your pupil supervisor and indeed other people in chambers, or you might be going to work-based learning, for example, with the Crown Prosecution Service. But it's, again, very often they will second pupils out to chambers to do work as well. So the whole idea, it's really a bridge between those two things. And what your pupil supervisor will want is someone who's well-grounded in criminal litigation and civil litigation, someone who's well-grounded in advocacy, both submissions and witness handling, and someone who understands the fundamentals and the fundamental template, if you like, for writing a good opinion, who understands the fundamental template for drafting. And of course, within all of that, we teach you, and it's part of something you're assessed on, we teach you other matters as well, including legal research. And also there is a discrete online professional ethics course. Professional ethics, it's worth telling you, is taught in two parts now. One part is on the bar course and another part is in pupillage. That's not just for on our course, that is whatever bar provider you go to, bar training provider you go to, you will be taking professional ethics in two parts, one on the bar course, one in pupillage. The advantage you have is that the Inns of Court College of Advocacy produces really great training materials for pupillage, and they dovetail perfectly with what you will learn on the bar course. That's the way we've set it out. So effectively, you do your first 4 modules on the bar course. That's, if you like, your foundation for professional ethics, and then you do a couple of advanced modules for pupillage. But they, for the ICCA, follow on naturally because we have produce those materials. So we think that's a real advantage for students. Kane, I'm going to pass over to you now, just so you can give everyone an idea of what it's been like doing part 2. Let me give you a helping hand here, because we were having a chat just before, and Kane was telling me that he's got to the stage where he's enjoying an advocacy, albeit it felt slightly overwhelming at first. So let me perhaps pick up on that point.
Yeah, like I was saying earlier, because of, we're coming out of the COVID period now, and with the in-person teaching starting, I think me, like a lot of other people on the course, were, naturally quite anxious about, doing advocacy in person and testing out all of these skills, which in many cases, many people hadn't done before. Things like, cross-examination, examination in chief, things that you don't do on your usual Monday to Friday. So, but when the actual course started, those nerves really dissipated really quickly. And as you get into the role with it, as it were, with the sessions, you begin to really enjoy them. Because after all, the way that the course is designed, you get given a brief as such, where, there's an imaginary case with clients and there's a whole story that's being created. So as you progress throughout part 2, you begin to get into the swing of those stories, and you begin to feel like it's actually a case that you're representing someone in. And it's also really satisfying seeing how your skills are proceeding. Because like I said, when everyone else starts off with cross-examination, very few people have done it before. So naturally, everyone's not particularly good at it to start with. But then as the course progresses, it's really gratifying seeing how much, where you've come from and how much you're improving. And I just want to say one thing as well, just to tag on what was said earlier. One thing I really like about the teaching on the course, and it's really refreshing compared to a lot of the other courses, I've studied beforehand, is that there is an emphasis on actually preparing you for life in practice alongside preparing you for the exams themselves, which I really like, because it's quite a realistic view of the fact that you're not doing this course just to pass it and then go do something else. You're doing it to prepare yourself for pupillage and life as a barrister. So I've really liked how a lot of my tutors have really not only explained things that are necessary for preparing for the exam, but have also gone above board and said, well, in practice, this is also very crucial. And I feel like in that way, I'm being prepared very well for pupillage.
That's really helpful. I can see that there's a number of questions coming through. Just to help everyone, I'm going to deal now with course cycles. I'm going to be dealing with fees. I'm going to be dealing with applications as well. So we'll be reaching that stage. But Patrick, can I ask you if there's anything coming out of what we've been discussing that would be helpful for me to answer at this stage?
I was just furiously typing an answer, Chris, but actually it might be a good one for Kane to deal with, which was, Kane, what's the provision of learning materials like? There's a question about books, etc. If I deal very quickly with what we provide on part one, and then if you want to talk about the part two materials in a little bit more detail, that might be really helpful. So in part one, the centrally set Bar Standards Board exams are based in crime on Blackstone's Criminal Practice, which is a major practitioner textbook that is used by judges and practitioners in court every day. And on the civil side, by the White Book, which has a similar status on the civil side. And in addition to the White Book, a book called the Jackson Handbook on Alternative Dispute Resolution. And those three texts are the texts on which all of the assessment questions are based. The BSB produces syllabus, which in detail tells you which provisions of those books you need to know. And our materials then are designed specifically to teach you those parts of the syllabus which are going to be assessed. So the ICCA materials complement and underpin the textbooks that we provide you with. But Kate, do you want to talk a little bit about part two materials?
Yeah, sure. Yeah. With part two, alongside the materials you were given in part one, you're also given a drafting manual as well, which is very important for the drafting aspect of the course. But really, like part one, with part two, obviously, well, the teaching takes place in person, so you're getting the oral feedback on the day. But a lot of the materials on the VLE are used to complement your understanding. So, for example, in the conference sessions that we're taught, so obviously we're asked to prepare using materials given to us on the VLE for an imaginary conference, but that we're also given kind of videos and pointers on the VLE itself, where some of the tutors have given explanations and guidance on how to prepare for certain aspects of the lesson. So well into part two, you get the complementary help of the VLE. And also by virtue of the fact that you're studying in and in of court, also you have access to their library. So as well as having all the access of the materials on the VLE, you also get access to all of the legal research facilities that the Inn offers you. So that's incredibly helpful, and not something that you really appreciate before you start the course, because when you start the course, you get used to the workload, and then when you're kind of naturally in the Inn of Court, you go to the library and you realize, oh wow, they have an absolute wealth of material available to you. So just an advice tip on that point: if and when you do get onto part two, make sure you use the Inn facilities, and the librarians there are really useful.
That's really helpful. Patrick, you were going to say something, I think.
I was thanks to Kane. I was just going to underpin what he'd said. The ICCA has a really positive relationship with the Inn's librarians, and the Inn's librarians are involved at the beginning of part two with taking students on a tour of each of the Inn's libraries so they know where to find things. And also they're involved in our legal research course as well. So they give a real insight into legal research, both in terms of the old-fashioned way that Chris and I will remember of going to the library and getting a book off the shelf and reading what it says, but also in terms of modern research, in terms of the use of Westlaw and Lexis and other legal databases to make sure that your legal research skills are as sharp as they possibly can be, both for pupillage applications, which is important because very often in pupillage applications these days, you'll be asked to do a piece of legal research, but also, of course, when you get out into practice as well. That was all I was going to say, Chris.
Lovely, thank you. Okay, let me talk a bit about course cycles now. I went through earlier when we were talking about part one, really how you could use part one. And we run our course, as I said, in two parts. If you did the first cycle, you'd start your part one in September. You could take your exams in December. And then you could, if you pass those exams, you can then start your part two in March, and you finish your part two in July, and you go into pupillage in September, October. Alternatively, on a second cycle, you could start your part one in January. You could then take your part one exams, your BSB civil and criminal exams in April. And then if you pass those, you could then move on and start your part two in September. And then that would be completed in early January, and then you would follow on from pupillage there. As I've said, and what we're finding, and this is really interesting, a lot of students are really interested in the flexibility of part one. So actually, let's say you have a September start, they're choosing not to take their exams in December, but in fact, they're taking them in April. If they do that, then they could start their part two in September. Alternatively, if they choose not to take their exams in December or April, they can take them in August, and then they could start their part two the following March. So there's an awful lot of flexibility, and the reason for that really, as far as I'm hearing it from multiple students, is twofold. It's either because they need the money, and we recognise this is the real world, and bar training, since we came back into the market, fortunately, it fell by a lot, but it's still a lot of money, and we utterly get that. The second part is that people are using it to gain experience of all sorts, either doing further academic work, such as research or as research assistants, or alternatively getting legal work, sometimes working as paralegals or in all manner of other legal positions. So it depends how it works. Some people I know choose to go abroad to do their part one because you can do it from anywhere. We had a number of assistants from, I think, were they the Court of Appeal, Patrick? They all got together and went off to Spain, I think.
Yeah, they were judicial assistants at the Court of Appeal, and they celebrated their end of that at the beginning of part one by doing their first 4 weeks of study in somewhere in southern Spain in the sun.
Absolutely. So there's so it's a point well made, actually, that there is an awful lot of flexibility. We know that students use that. Other students, I know, Kane, you started, I think, in January, and you did your exams in April. That's right.
That's right, yeah. And I talking about, being able to use the time for work experience as well. I had the down period between April to September when I started part two. And that was really valuable to me because that enabled me to do some more volunteering work. I did some work at the free representation unit. So that downtime, which may seem like quite a lot beforehand, is actually really important when you're trying to cultivate your CV for pupillage applications, because you'll often find that, not that it's impossible, but particularly during part two, but also part one, you've got your focus on the content that you've got to, master. And that period of a few months between part one and part two is really valuable, being able to, expand your skills and gain valuable experience.
That's really helpful. Yeah, I mean, if you, for example, did your part one from September to took your exams in December, you could then use that downtime between Christmas and March to actually make your pupillage applications, because the pupillage gateway actually opens in January, closes in February. So it's a very useful time where you could be focused just on that. So we've given a lot of thought to how this work fits together, but I appreciate it sometimes takes a little bit of getting your head around as to exactly how it works. But I hope that gives you an explanation. If you go on to our website, go on to the studying with the ICCA page, then that gives you quite a few examples, actually, of how a number of examples of how different cycles can work in your favor. Okay, I hope that helps. Let me move on to fees, because I appreciate that fees are important. You just don't want to just know how successful the course is and what your prospects of getting pupillage are, but also how much it's going to cost. And as I say, we live in the real world. For our 2023 and 2024 course cycles, part one of the course will cost a total of £2,669. Let me break that down for you, because that's an ICCA fee of £1,688, a textbook fee of £511, and a bar standards board, what's called an intake, or really an assessment fee of £470. So when you look at the 2669, that is an all-in fee. That includes all of the materials you'll need, all of the resources you have on the VLE, all of the textbooks you require for the assessments. Part two is a total of £12,161. That is the ICCA fee of £11,926 and the BSB fee of £235. So the total combined cost of the bar course, inclusive of all BSB fees and textbooks, is £14,830. Let me just tell you this, because there's a lot of misunderstanding about this. when you sign up to the ICCA Bar Course, you do not contractually bind yourself to paying £14,830 because you only pay for each part of the course if you choose and when you choose to enroll on that part of the course. So we wouldn't come to you for the Part 2 fee when you accept an offer. We wouldn't even ask you for a deposit because that's not what we do. We don't charge you any administration fees. When you enroll on Part 1, you will be asked to pay that fee. When you enroll on Part 2, and only when you enroll on Part 2, will you be asked to pay that fee. And on Part 2, there's multiple flexible options, multiple payments in various instalments, etc. For people that find themselves in particular difficulty, we have a hardship fund to assist them if they find themselves in an impossible financial situation. The whole point of doing it in this way is that real life doesn't always work in our favour. Let's say, for example, you do Part 1, or you find in Part 1 that due to a family or other issue in your life, that you're not able to do Part 2 at all. We say really you've got to complete Part 1 and finish Part 2 within a 3-year period. And we suggest you do Part 1 in no more than a year because you don't want what you learned at the beginning to start being stale, if you like, by the end of it. But if you find, for example, you simply cannot go on to Part 2, we would not charge you for it. We want to be absolutely clear and as helpful as we can possibly be, because we recognise this is expensive and you want something from something out of it, frankly. So that's what we will do. So we hope that significantly reduces the financial risk for you. You can find all of this information on the fees page of our website. We recognise funding is an important matter for students. Many of you will know that the Inns of Court provide over £6 million of funding, both for law conversion courses, graduate diploma in law, and also for bar course students. For those of you that haven't yet applied, I can tell you that scholarship applications for the bar course close on the 4th of November. So you can look those up on the individual Inns websites, but really important if you're thinking of bar training next year to get those scholarship applications in, okay? So I'm glad I remembered to say that because I know if you miss it, you've got a problem. You can apply for those scholarships irrespective of what bar course provider you attend, but nonetheless a number of our students come with those. I'm pleased to say that the Inns of Court College of Advocacy is also introducing a bursary scheme for applicants at this particular stage. Our first bursary scheme is in fact funded by the Chancery Bar Association. In order to get that can pay up to 1/3 of your fees if successful, and you've got to demonstrate that you're committed to Chancery work, that you would have a significant financial difficulty taking up your place on the bar course. Also in terms of the type of student that is engaged with the work that the Specialist Bar Association is engaged in, that student is generally underrepresented, has a background that's generally underrepresented within that specialism. I'm pleased to say, are working extremely hard with other specialist bar associations, and we anticipate that in due course there will be bursaries not just provided by the Chancery Bar Specialist Bar Association, but multiple others as well. I can't say who they are at the moment because I get in trouble. But there we are. That's what's going to happen. We don't do an LLM option. Because we take the view that an LLM is, if it's going to be meaningful to the bar, it's best carried out at a very good university as a separate course. It's not that we don't want to do it. We are, as many of you will know, linked to a very good university, which is King's College London, but we know at present the cost of actually doing an LLM with King's College London would be prohibitive. But we are looking into the future about why we might be able to do that in a more affordable way.
Sorry to interrupt. Just while you're on the subject of the bursary scheme, there's a question from Wayne who says, "Is there a separate application process for the Chancery Bar Association bursary? Do you know how that's going to work as yet?"
Yeah, I can tell you it will be an online application. It's currently actually being finalised. If you're applied to us already, or you're about to apply to us and it doesn't pop up, do not worry. I'm underlining that and putting it in capitals, because we will contact every single person who makes an application and notify them of how to make an application for a bursary. So you will not, if you get your application in now, do not worry, you will be told in good time about that. So I'm sorry it's not actually up on the website right now. I think an announcement about it is, but actually the application detail isn't, but you will be notified, everyone will find out. Let me just deal with applications, because we don't apologise for the fact that we are selective at the Inns of Court College of Advocacy, but I'd hope you to think that in some ways we are doing that because we want to become an elitist organisation. Quite the opposite. The Inns of Court College of Advocacy has students and has taken in students from over 50 different universities. We have students from all number of backgrounds, socially and culturally. We have career changers, people of all ages have come to us. And what that actually means is that we actually pull together and bring together an extraordinary and diverse community of students with a wealth of different backgrounds. And that makes a real difference to us, because we want to be a supportive and dynamic community. Fundamentally, it's that diversity that is going to enrich the bar and make the bar survive for the future. As many people have said, and I'm not the first, that the bar needs to reflect the society it serves. We have driven that. We have a fair admissions policy which was put together by many of us, including myself and a wonderful lady by the name of Bindi Dalakia. And Bindi is the co-author of the Bar Council Fair Recruitment Guide. And so therefore, we do not take into account what university you attended, what school you attended. We do not take into account your protected characteristics, unless you particularly want us to, for whatever reason. We welcome people from all backgrounds and all fundamental. I saw something earlier about disabilities. Disabilities, of course, are not an obstacle to people getting on this course, and within the course we provide whatever the disability happens to be, we will make reasonable adjustments, of course, whether it comes to assessments or learning for that to happen. So that is how we work, and I can tell you why we're selective. Because if you could put together, for me anyway, in a word, what the sort of student we want, and Kane's a good example of this, it's someone who has the requisite level of enthusiasm, because that enthusiasm is really important. You can imagine if you're sitting in a very small group of advocacy, you need to rely upon one another in a small group like that. You need to look after each other. And if one person turns up who actually hasn't put in the time, hasn't got the same level of motivation that you have, it really can bring that class down. It can affect the learning of people who have put the effort in. And that's what we're really focused in. We are not, let me underline this and also put it in capitals, looking for the finished article, because if we were, what would be the purpose in us of being a learning and teaching institution? I'd hate you all to think that in some way, oh, we only pick students from certain universities, we only take students from a certain background. That could not, I repeat, could not be further from the truth. But we are selective. We're selective in line with our fair admissions policy. We are absolutely clear about what we ask you, because if you make your application, but even before our applications portal opened, you could have looked up the application process on our website and you could have seen exactly what questions we ask you, not just what questions we ask you, the criteria that we measure your answers against. So we just want to be clear that you actually are motivated, that you have the requisite level of communication skills, and that you are determined. And if you are that, then we bring you along we ask you to come along to a short interview and a short advocacy exercise. 10 minutes for the interview, 10 minutes for the exercise, and I can tell you that it really is not meant to be scary. In fact, I haven't asked Kane this. Kane, tell us how it went for you.
Well, I actually have quite an interesting story, because I want to say, just point out how accommodating the interview actually was. So during my interview, unfortunately, my internet cut out 2 times, which, as a lot of you can imagine, is probably not the most comforting thing to happen during your interview. But I was really struck by just how accommodating, the interview was, and how, even though I was having an absolute nightmare on my end with, connectivity issues, it was all still very, the communication was excellent. And I felt the interviewer was really listening to me despite the technical issues I was having. And I also wanted to say as well, talking about the admissions criteria that's available on the website, for my experience, because I was applying for in scholarships around the same time, you'll find, obviously, as you pointed out, the deadline's coming up. They're very much in sync, which I quite liked. There was quite a clear approach to the criteria that not only the ICCA was looking for, but also the INS. So you'll find that writing your application through the written stage for the ICCA will serve as good practice for a scholarship application, and vice versa. And it really, the questions that you ask really make you think in your own mind about, why you want to do it. And you'll find that if you have a really clear reason why you want to be, continue with a career at the bar, that will really shine through in your application. And it's also reflected, like Chris said, about the sort of student that's on part 2 as well as part 1. Everyone wants to be there, and everyone has a genuine enthusiasm about, pursuing a career at the bar.
That's really helpful. And I can see, and I should have said, what are our fundamental academic entry requirements? If you've done a law degree, you need to have a 2-1 minimum. If you've done a non-law degree, we'll accept a 2-2, but with your GDL result, or whatever your GDL course is called, you need to have a minimum of a commendation. So commendation or distinction we'll accept. We won't accept a bare pass. If there are mitigating circumstances for those that have already received their GDL or their law degree results, then we will consider those. The mitigating circumstances application is made online as part of the online application process, and all of those will be individually considered. So we have mitigating circumstances where there are good reasons as to why you didn't meet what you'd normally expect to meet in terms of your academic entry results.
Chris, can I just put a couple of questions to you that follow on from that?
Of course.
One is, how does the offer process work if somebody is just completing their degree or completing their GDL? How do we deal with that situation?
Yeah, you simply predict what you expect to get. We don't ask for a reference from a tutor or any other academic as to that. You just tell us what you anticipate to get. So you don't need to pass your degree in order to apply. You can just predict your grade. You will receive, if you go through, when you get an offer, it will just be conditional on you having a law degree 2-1, or alternatively a non-law degree 2-2 and a GDL minimum commendation. That's how that works. So predicted results are absolutely fine.
Just secondary to that, Chris, a question from right to the beginning of the webinar. Apologies, it's taken us a while to get to this. But what percentage of applicants do we interview, and what percentage of those who are interviewed go on to be offered a place? Do we?
It's irrelevant. It's irrelevant. The percentage is irrelevant because, of course, that will change according to each application cycle. In many ways, the question suggests that we set our parameters in advance. That's exactly what we don't do. As I say, we accept applicants from all over the place with all manner of backgrounds in the fairest possible way that we can. So I hope that answers that. If you are an enthusiastic student with the entry requirements, who meet the entry requirements, I have absolutely no doubt that you will be able to get yourself a place on the ICCA Bar Course. So that's really what matters. I just want to tell you that, of course, once you pass a course, you will get a postgraduate diploma in bar practice from King's College London. That's our academic validating partner at the Dixon Poon School of Law. You will, of course, be able to get called to the bar, because that's the whole point of doing this for many people. As long as you do your you pass your fit and proper person check at your inn, and you complete your qualifying sessions, which are conducted by your inn. If you want to know more, and I appreciate these are always relatively short webinars, we have an open day which is being held at the Inner Temple, just where Kane was telling you about moments ago. It's being held at the Inner Temple on Saturday, the 29th of October, between 10 and 1 p.m. We have a webinar next Wednesday, the 26th of October, specifically on the application process. So again, we can answer any questions you have about that. We have further webinars about mooting and pupillage interview advocacy. That's on the 8th of November. At Success in Obtaining Pupillage on the 10th of November. If you go onto our website, you'll see ICCA Bar Course at the top of the drop-down menu. If you go onto ICCA Bar Course events, all of those events are there and you can register and sign up for them. And it would be an absolute delight, of course, to meet everyone in person. I appreciate there's different quality to that, and it would actually be nice to see the people behind the screen, as it were. I think that brings us to our hour. I've got to say thank you to Kane. You've been extremely helpful, and I hope it's been useful to all of you to have Kane here. Thank you to Patrick for not just for answering so many of your questions, because we know that you had a lot of questions, but for telling us all about part one. And thank you for showing an interest in the ICCA Bar Course and joining us today. And as I say, it will be an absolute pleasure to see you in person when you join us in due course, or at least in one of our events over the autumn. Thank you very much. Goodbye.
Thanks, everybody. Bye-bye.